the 8th Circuit Court here in Missaukee County. And we took care of a pretrial conference earlier off the record. So now we're moving to our docket call. And our first case today on the docket is People of the State of Michigan versus Tiffany Jacobson. This is file number 25-3606FH. Appearances from counsel. Begin with the prosecutor, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor for the Missaukee County.
Good morning, Your Honor. Allison Castle on behalf of Miss Jacobson.
Good morning, Your Honor. Lisa Kirsch-Satawa, also on behalf of Miss Jacobson.
Thank you. Both counsel for the defense are appearing this morning via Zoom with permission by the court, and also joining us this morning via Zoom from a Department of Corrections facility is Miss Jacobson. Miss Jacobson, are you able to see and hear the court?
Yes, Your Honor.
All right, thank you. Ms. Jacobson, again, I remind you that you have the right to be physically present in the courtroom, but it's my understanding that you waive that and are allowing us to conduct today's sentencing via Zoom. Is that correct?
Yes, Your Honor.
Thank you. Any objection to that, Ms. Castles?
No, Your Honor.
Also here this morning is Mr. Luke Blazak. He is the agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. Let's begin with the prosecutor. Mr. Ringstrom,
I have had
amendments, corrections, or objections to make?
I have had a chance to be able to review the report. I personally do not have any amendments or corrections. I do understand that OB 12 probably should be scored less though.
Okay, so by the way, while we're waiting for you guys to come in, he told me you just had 2 challenges. So let's go ahead and talk about the first one. Ms. Castle, you're challenging offense variable number 12, as I understand.
Yes, as it relates to both offenses, offense variable 12 is for the contemporaneous felonious acts. In doing their calculations, probation calculated this based on possession of methamphetamine, felony firearm, and carrying concealed weapon. MCL 777.42 excludes felony firearms for being counted on for this variable. As a matter of statute, we believe that should have been properly scored as a 1 rather than 10.
All right, thank you. And Mr. Ringstrom, your response, sir?
I really don't have any objections to that, Your Honor. The possession of meth was what she had pled to was a lesser included of that, and I do know felony firearm can't be used. So
Okay.
I personally don't have any objections to it, and having it scored as 1 is okay.
All right. All right, thank you. All right, the court will grant that objection or challenge. We will therefore reduce offense variable 12 from 10 points to 1. And that's going to modify the total OV points for the first count, which is weapons firearm possession as a 3rd habitual offender. That will reduce it down to 11 points. And I know there's going to be more. Just a moment, though. So that in and of itself would not change the OV level. Then we're going to look at count 2, which is the delivery, and that is going to modify OV 12 again from 10 to 1, and that will reduce the total offense variable scoring from 25 down to 16. And that offense, that would go down from a category, an OV level 3 down to an OV level 2 thus far. All right, Ms. Castle, your next challenge.
Next challenge is to the scoring of offense variable 14, the offender's role in the situation. Ms. Jacobson was scored 10 points, indicating that she was the leader in a multiple offender situation. Well, we don't dispute that there can be more than one leader. That's not what happened in this situation. The People v. Hayes is a Court of Appeals case decided in May of 2023, through which the court remanded for resentencing, where the defendant was scored as the leader under this variable, but his actions didn't show by preponderance of the evidence that he guided, directed, or otherwise was a primary causal or coordinating agent in the criminal transaction. That's what happened here as well. Ms. Jacobson was not a leader in the situation. The co-defendant, Miss White, was. Ms. Jacobson testified against the leader of this incident at the prosecutor's request. As she testified at trial and informed the police, she wasn't working with Molly White. She didn't provide Miss White with any controlled substances or help her to obtain them. The only basis for calling Miss Jacobson a leader is that she was driving the vehicle. It was her car. And so it makes sense that she would be the driver. She did not learn about Miss White's intentions of selling controlled substances until she was in prison and heard this from another inmate who was the intended recipient. But Miss Jacobson had no information, and I don't believe that there is a preponderance of evidence to establish that she's any degree of leader in this situation.
So far that it seems like a lot of that is going as to count 2. Let's talk a little bit though about count 1, which is the felony firearm. Mr. Ringstrom,
Yes,
let's
Your-
focus on that portion first. Go ahead.
We can focus on that portion as far as the felony firearm first, Your Honor. She is the one who had possession of the gun. She admitted it was her gun. Not that it really matters as far as it goes, but it was a loaded gun at that point in time and did have 2 bullets that were in it at that time. At the time of the pullover, she wound up passing that gun back to one of the passengers, Austin Ware, and basically told him, hey, hide this and everything. At the time, Austin Ware was actually charged with a felony firearm also because he was the one who had the gun and all of that stuff. So for those purposes, I do think that she would be considered a leader in that regard, because there was 2 people that were originally charged with it. It was her gun. She's the one who passed it back to him.
All right, thank you. Let's focus on that first argument. Ms. Castle, you kind of talked about the second count. Let's talk about count 1 though first, regarding the firearm.
Between those two, the passing back following Mr. Ringstrom's theory of how the case occurred, passing it back, there's no indication that she was the one who loaded or that she knew that it was loaded. Notably, when police encountered her, it was not physically in her possession. It was under a seat, I believe. I don't think that is enough to say that she's the leader of this multiple offender situation, as the facts don't support that to a preponderance standard.
She admitted, Mr. Ringstrom, she admitted to having the firearm and turning around and passing it back to somebody else, correct?
She wound up, I believe she admitted that at her plea process, that it was her gun, that she knew it was there and all of that. And
I remember her testimony. She did a very good job testifying. So, all right, the only thing here is when I look at it, was she the a leader, or did she just pass it back to a guy? I wasn't in the vehicle. No one here was, except for the defendant, was in the vehicle. Was she merely trying to hide evidence? Maybe. I think that's probably the best thing we could interpret. She definitely knew about the firearm. I don't buy the argument that she didn't know it was loaded. I mean, it was her firearm. So yeah, I don't buy that at all. Of course, why she was driving with a loaded firearm, unlawful, in a vehicle, carrying concealed, those are probably different arguments, and that I can take into consideration when I establish my sentence. So at least for count 1, I'm going to go and change that from 10 points down to 0 for OB 14. That's going to bring total points down from 11 to 1. That'll bring the OB level down from 2 to 1. And that makes the guideline range dip just a little bit from 12 to 36 as a half third down to a 9 to 34. Plus, we're going to be conservative and eliminate any appellate issue there. So now we're going to turn to count 2, and this is the delivery and whether or not she was or wasn't a leader there. Now, this is where Ms. Castle began her argument. I think she's already covered it. Mr. Ringstrom, go ahead on your response to that portion.
it was her vehicle. She was the one who was driving it. Testimony at the trial, which the judge heard.
Yeah.
They were all smoking it in the car and all that stuff. Ms. Jacobson admitted basically that she knew what was going on. And there was actually more than just possession, it seemed. It seemed like there was delivery going on as well.
And she testified that she was there when Miss White was on the telephone and said, hey, we need to go here, drive me here to go get the meth. So,
Yes. So I believe all of that could establish that she
Yeah.
was a leader along with Molly White, but
yeah, I mean, the other guys, the two gentlemen in the back seat, they were just along for the ride, getting high and going to the store. Ms. Castle, anything to further say there in response?
I would just further state that her lack of knowledge in actually putting this all together for purposes of delivery. Yes, she was aware of the drugs in the car, but was she aware of Molly's plan to and then deliver it is being I believe that her being present while Molly was on the phone is insufficient to say that she was a leader, as Miss Jacobson wasn't on the phone. She wasn't aware of who she was speaking to. That's where that nexus is. It's not strong enough to say that she was a leader.
Can you become a leader by accessory in the middle when she found out? Because what she testified to was Molly was on the phone. Molly told her, we need to go here to go pick up more for deliveries. She testified that Molly told her what she was doing. And so then Molly only could have gotten there if Miss Jacobs had driven her car with Molly to the place to go pick it up. Isn't that a lot like a driver in a drive-by?
I think of that more as her being led. She was led to drive. She was taking
How was she led?
direction.
Yeah, she's the one that had the gun. So how was she being led to drive? Did Molly White say, do it now or I'll hurt you? She just said, hey, turn the steering wheel to the right. And then Miss Jacobson turned it to the right. She couldn't have gotten there. She could have said no. She could have, because she didn't know Molly, is what she said. Miss Jacobson her testimony was very open. I thought she did a very good job testifying. She was, again, she came across very believably. All right, so hold on. Let me just take a look here for this moment, for a moment. Is the habitual only as to, that's only as to the count one, correct?
yes.
All right, thank you. So, but what I'm going to do is eliminate any appellate issue as the scoring. I think the argument isn't the winner, but I'll grant it to eliminate that appellate issue. Therefore, that's going to reduce offense variable 14 from 10 to 0. Again, I don't buy the argument, but I'm going to do it by eliminating, looking forward down the road and eliminating that potential appellate issue, which again, I don't think is a winner, but I'll still. Therefore, we are now reduce the total EOB points from 16 down to 6. That changes the offense variable level now from the 2 that we had previously down to a 1. And that's going to give us a sentencing range of 9 to 23 according to the guidelines. All right, Ms. Castle, any other challenges to any other part of the PSI?
No other challenges.
I'm sorry, no, you go ahead. I know.
No other challenges, just some factual corrections.
All right, thank you. Mr. Ringstrom, before you say it, I'm going to say it. We need to change the date on the page 2 or page 1 of CFJ 145. Plus, and she's currently serving a sentence, so while we would have to make an amendment on CFJ 145 page 2 under the jail credit section, that would change that end date from January 5th to February 2nd. But again, the credit is 0, but I do think it's worth noting that the parenthetical of the 101 days, that's going to have to be changed to 128. Nobody criticized me if I did my math wrong. Well, you can criticize me if I did not do math well. But I think it's 128 days now. Okay. All right, Mr. Ringstrom, any other corrections, amendments, or challenges to make to the contents?
No, Your Honor.
All right, thank you. Ms. Castle, now you said you had some factual allegations or concerns. Go ahead.
Just really quick about to make a correction about her credit. It's my understanding that the The prison sentence terminated on the 5th, so she would have been entitled to credit from the 5th to today.
Okay. Well, actually, no. Did she enter? Hold on. I don't remember when she entered her plea. Just a second. Actually, if she entered her plea on November 14th. Well, but she's already serving a sentence. So how does she get credit when she's serving a sentence? I can take it into consideration. I'll agree with that. But I don't think she gets dates or time toward credit.
My understanding was that she completed her prison sentence on January 5th, so the time interim from now to then.
I'm sorry, I missed that. You did say that. Mr. Blazak, did she finish her sentence?
It's my understanding that she's still in prison.
Well, I know she is. I can see her. But
So she would have,
if she had completed her sentence, she would have had to have been brought back here to Missaukee County Jail. Because there wouldn't be any lawful detention of her in the prison system.
yeah, I'm not aware that they would hold her for.
Let's take a quick look here at CFJ 284 section. And 1 second. So she was sentenced on September 26th of 2025. Do that right. 1 second. Sorry. Well, it'd be really close. She would have to have had she'd have to serve the minimum of 14 months.
That would be her earliest potential release date.
Yeah, but if she had 314 days credit as of the sentencing date on September 26th, she would have earned another 400 and I'm sorry, she would have earned another 96 days. Is that right? Yeah, 96 days. So that's 410. That would give us roughly 13 and a half months. So what I don't know is I don't know what the parole board did. Did they release her? Did they grant her? I don't know. So here's what I'll do. I'll leave it up to the defense or somebody to file a motion to modify an unlawful or invalid sentence if they give me proof that she actually was released by the Department of Corrections. Likely she may have been, but if she had been, there's no way she could, I don't know how she would be able to be in prison. Oh, Miss White, I'm sorry, Miss Jacobson, you got your hand raised. If there's something you wish.
Your Honor, I'm sitting on a deferral right now. My ASAT class, I just finished my midterm with all perfect attendance and all assignments, all correct. And I get off on the second week of February.
Okay, so you haven't done, thus far you have not finished that sentence, is that right?
I finished the sentence. My parole class is over the second week of February, and that's when I'm completely done just with my class. So everything's done, just my class ends on the second week of February.
I think I understand that. So the point is she's still serving a sentence.
That's correct.
Defense can make that argument for the court to take into consideration, which I'm able to. but whether or not she actually is entitled to credit, I don't think she is. All right, next, Ms. Castle. You said you have other factual
Yes, yep, I do.
challenges.
I'm just trying to get notes back together.
Okay.
Under the personal history section of the first page, CFJ 145-1109, under personal history, it states that she's unemployed. She was employed as an in-home healthcare aide for her mother-in-law at the time that she was arrested. Upon release, she'll go back to this role.
Mr. Blazek, does it need to be changed, or technically she's unemployed, but she's, maybe you call it, she's on vacation, or I don't know, permissive leave. I don't know what the right phrase would be, but
It says,
yeah, I mean, right now she's not employed, because, like, for instance, you could have somebody who is here for sentencing who wasn't in confinement, was on bond, and was employed. But right now, so I'll leave it as unemployed, but again, Ms. Castle, making that argument is a good argument for me to take into consideration. Again, when you look at the PSI program that they use, there are only so many choices they have. I can tell you that sometimes I wish they had an other, and you can type in, but all right, thank you. You may continue. Next.
Yes, I'm sorry.
I would say I believe that's all. Aside from just corrections to the credit to reflect the time that's lapsed, since if the court's willing to consider that, if not, that can just be reserved for argument during elocution.
Yeah, that we're just going to leave that reserved for argument. Again, I can take that into consideration. Whether or not it is required to be counted as credit is a different question, and I rule that it is not. All right, allocution then, Ms. Castle.
Since Ms. Jacobson's initial interaction with law enforcement for this case, she's been entirely cooperative and taken accountability for her actions. She consented to the search of her vehicle, answered everything that the police officers asked her, and didn't give them any trouble otherwise. While in MDOC, she's had no tickets, no warnings, or otherwise any reprimand, and her pattern of cooperation continued as she willingly agreed to testify against the co-defendant about what really happened in this case. If the court's inclined to max Ms. Jacobson out at the top of her guidelines, she would be staying in prison with the people or with the person whom she testified against, and with there only being one women's prison in Michigan, her safety is a serious concern. Based on the sentencing guidelines, Ms. Jacobson is eligible for any additional custody ordered to be served in county jail, and Ms. Jacobson deserves this opportunity. While this case has been pending, she's been actively involved in rehabilitation and making life-changing improvements. She's made great progress with her ASAP program, as she mentioned. It's a 3.5-month intensive substance abuse class. She's had perfect attendance there, no tardies and no reprimand. She's also been working in the kitchen while at the prison, and she's additionally been trying to work towards getting her GED. But if she were to be released very soon, then she's also paid tuition for an outside GED program, not through the correctional system. Prior to arrest, she was the full-time live-in caretaker for her mother-in-law, who has been present at all of Miss Jacobson's prior court proceedings. Her mother-in-law has a variety of serious ailments and relies on an oxygen tank and Miss Jacobson's care to survive. By sentencing Miss Jacobson to a term at the county jail, her mother-in-law would be able to see her and offer her support to Miss Jacobson as she continues to succeed through sobriety and making these substantive improvements. Miss Jacobson has been clean from drugs for over 9 months now, and she has no intention of going back to that lifestyle. She intends to continue with her treatment and remain sober as she understands the negative impact that drugs have had on her life and the consequences that they bring. She advised me when we spoke about her PSI that a family member has been calling to get her involved in inpatient residential treatment following her release. If she's able to secure a bed at a residential treatment facility, we would ask that she be allowed to be released from custody into this treatment program to continue her progress. And upon release, Ms. Jacobson will have or will still actively be working towards her GED and intends to care for her mother-in-law for as long as she needs. She'll also have housing through her mother-in-law. So we're just asking that she be sentenced to the low end of the guidelines due to her cooperation with law enforcement and the steps that she's taken to not come before the court again in the future. If the court is willing to sentence her to a term of house arrest with GPS monitoring and any other conditions needed to ensure community safety and her compliance with conditions, this would allow her to resume providing care to her mother-in-law. But if the court's unwilling to allow this, we would ask that Ms. Jacobson be sentenced to a short term at the low end of the guidelines at the Missaukee County Jail.
Thank you. Mr. Ringstrom?
Well, I agree that after Ms. Jacobson got caught, she has been very cooperative. I agree that after she got caught, she has been doing all the services that is being stated and all of that stuff. I agree that she did testify for prosecution, that she, like your honor said, I believe she tested very honest. I believe that she did a really good job with her testimony. I believe that her testimony would have wound up potentially even supporting a delivery of meth instead, but that's besides the point. For that testimony, she got a really good plea bargain here as well. And that was something that we had considered at that time. I mean, I agree with all of that stuff. Ms. Jacobson, since she has got caught, has been doing a phenomenal job. She was still carrying around a loaded gun while delivering meth and all of that stuff, which is something that I don't think our society really likes as a whole. I'm gonna leave it up to the court as far as this decision, as far as what to do. I also agree, and I don't remember Ms. Castles had said it or not, but January 5th, she was supposed to have been sentenced and was unable to be sentenced because the attorneys had not got a hold of her. And that should have been brought up as far as some time that this court should consider as far as being less.
All right, thank you. 1 second. All right, Ms. Jacobson, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say?
Yes, Your Honor. I humbly come before you to express my sincere remorse and my commitment to change. There's no excuse for what I did was wrong. I'm truly sorry. I'm sorry to my family for leaving them with my responsibilities because of the choices I made. I want to make it right and make amends, and I'm willing to do whatever it takes to make this happen and be reunited with my family. I've worked diligently each day of my incarceration, preparing for success upon re-entry. I've developed new healthy habits and have a new mindset focused on future goals that I've created in alignment with my values so that I may earn my freedom and reunite to society with my dignity intact. That includes my ASAP, my Suboxone program, and my classes and working in the kitchen. I'm able to come clean and admit my wrongs and begin making amends. I take this very seriously. I've secured housing, unemployment, and have supports in place. I'm 100% committed to putting safety first and obeying the law. I will continue taking incremental action steps while remaining in recovery so I can change, so I can be the change I deserve to be.
All right, thank you, Ms. Jacobson. One of the interesting things about being a judge after having been a prosecutor and a defense attorney is that I no longer represent either party, obviously. And it's now finally when we get to sentencing that a judge applies his or her discretion. And in trying to reach a sentence, there are a lot of factors that I take, in addition to those that are argued by the attorneys. First, I'm going to compliment you, as I already did earlier. You came in here during the trial with Ms. White. You were here without having counsel present, and you testified very credibly. and very openly and thoroughly. And so the concept of taking it on the chin, you've done that. You admitted up to your errors, your bad choices here, and I welcome that. And the comments that you've made today stand out to me, believe it or not. Not a lot of people involved with this kind of criminal history and involved in this demonstrate to me what I really believe to be a sincere position, a sincere understanding, a sincere acceptance of responsibility. Normally, I just get the desperation. And so I compliment you on that. On the other side, there are a lot of factors. You know, not only were you operating, not only were you carrying a concealed weapon, you were carrying a loaded weapon inside of a car, which is an unlawful transport. So there's another misdemeanor that you saved yourself from, the CCW, a felony. Plus you were operating while under the influence, putting everybody on that roadway in danger. You were smoking meth at the time. Everyone in the vehicle was handing the pipes or whatever it was, I forget now, back and forth. So there are at least 2 misdemeanors and another felony out there. Now, I know the felony was taken into consideration for OV-12. I got that. But I'm just highlighting that in addition to that OV-12, there were multiple offenses. I'll also note that had you been convicted at a trial for a Class B of delivery of meth, the minimum guidelines would have been at least 72 to 180. That is a presumptive prison sentence. So by doing what you've done, by working with your through your counsel with the prosecutor's office, you've done a very good job of bringing the maximum down from 480 months down to 120. Am I right? No, 50, 60, sorry, there we go. And bringing the minimum guideline range down from easily what would have been 10 years down to a guideline range somewhere hovering right around a 1-year sentence. So you've gotten a significant benefit here, and I appreciate that. Again, I appreciate what you had to do to get that. One moment. Actually, was it a 4th habitual offender or was it a 3rd? Actually, if it was a 4th, yeah, it was a 4th. Brought it down from, yeah, you brought it down from life.
She was charged with possession.
Yeah.
We didn't have any evidence of delivery at that time.
Which changes that guideline range from the 72 to 180, from 72 to 240. You've done a really good job here taking it on chin, and you've also got a significant benefit. And you've been doing a lot of the right things at the prison. Now, the others on the other side, I'll have to tell you that, you know, I speak at public events, or I write articles, or I participate in panel discussions. And the number one concern that every citizen raises to me is this. You have this whole incident here was, other than sexual assault charges involving children, this is the number one concern for every resident in Wexford and Missaukee County. Driving, drinking and driving, but this one was driving while inhaling meth, rolling around with loaded guns, and delivery of controlled substances. So this is at the top of all the concerns for the people of this county. I hear it every time I talk to people about what's going on in the courts. Now, at the same time here, you've had a history. It's not overly extensive, but for a person who's 35, and there's a fairly significant amount. And it really kicked in the most, I think, in the last 5 or 6 years. That's when, you had 2019, you had the assault resist the police officer. While on bond for that, you picked up a delivery charge, which was reduced down to a possession. And then while you were 9 months after being released from probation, you picked up another meth case. And while you were on probation for that, you made it about 7 months before you picked up another methamphetamine charge. And you picked up actually 2 probation violations in that file. Meantime, you had an unlawful use of a motor vehicle going on. Then entry number 9 of 11, that's when you picked up while on bond a receiving and concealing stolen property. There you also violated probation. Then 2023, while on probation, you picked up another larceny charge. And I'm going to tell you, one of the things that stuck out to me is there are multiple, they weren't drug charges. They're typically property cases. You had an embezzlement as a juvenile. You had 1, 2 different retail frauds, plus the receiving and concealing, plus the unlawful use of a motor vehicle in 2022, plus in 2023, another theft case. And then you pick up this case. And you picked up this case while on probation. So there's a balance here, and I've got to figure out what the right balance is. And again, I commend you that I believe you. I think you've gotten some corrective measures here. So let's focus on those positives. All right, one moment here. All right, the sentence of the court is as follows. The court sentences the defendant with 2 $68 state minimum fees, a $130 crime victims' right fund fee. And I'm not going to assess any costs, and I typically do even for those that are in prison because I'll make payment of those conditional for parole. I'm not going to assess any fines based upon the same concept. I will, however, assess a $300 attorney fee. There is no DNA fee here because DNA was clearly already available. As to count 1, the weapons firearm, the court does, within the discretion, exercise to sentence the defendant as a 3rd habitual felony offender. However, I am going to sentence, while I'm going to sentence the defendant to a prison term, it's going to be toward the bottom of those guidelines. So for this count, the court sentences the defendant to, I'm going to say 13. And then what I'm also doing here for the record is I'm taking into consideration that she's been sitting in jail or prison, even though she's not entitled to credit. I think what I'm doing is recognizing that and reducing it a couple months just in my mind. And so I think I'm already doing that. So that is 13 to 120 months. And the defendant receives the 154 days of credit. As to count 2, which is the delivery, anybody help and deliver drugs, you've got to expect a prison sentence. If you score a prison sentence, you're going to get a prison sentence here generally. I'm not saying I don't take into other factors in consideration, but that is the #1 concern for most of the citizens in these 2 counties. Delivery of drugs. 66% of my caseload is criminal, and of that 66, 2/3 of it, another 66, are just methamphetamine. So that's it. So here the court is going, and I'm recognizing the fact that this is the methamphetamine, and the court sentences the defendant to a range of 15 to 60 months, again with 154 days of credit. Have I missed anything, Mr. Van? Sorry, not Mr. Van. Mr. Van Amel, you are Mr. Blazak. Did I miss anything, sir?
Just clarification, I guess, whether those are concurrent or consecutive.
Oh, sorry. Yes, they run concurrent. Thank you. I apologize. I didn't mention that. They run consecutive to whatever sentence she has left to serve. That's keeping her in the prison right now. All right. So Again, count one, 13 to 120, exercising the discretion to sentence as a third habitual offender. As to count two, it's 15 to 60. There is no habitual enhancement there, and each one she gets 154 days of credit. Mr. Ringstrom, any questions, or do you believe I missed anything?
No, Your Honor, I think you got everything.
All right, thank you. All right, Ms. Castle, is there anything you think I've missed?
No, Your Honor.
All right, thank you very much. All right, Ms. Jacobson, you will receive there at the prison 2 copies of one document. This document is entitled at the top, your notice of right to appellate review. You have the right to appeal the conviction and sentence. However, based upon the fact that there was a plea of guilty, any appeal must be done by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, if you do choose to file an appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document that will be provided to you and return to the court within 42 days. All right. Anything else, Ms. Castle?
No, Your
I'm
Honor.
sorry, Ms. Satawa, you took off your mute. Go ahead.
I did, Your Honor. I just wanted to place on the record that Ms. Castles did visit Ms. Jacobson in person and reviewed the PSI in order to
Great.
ensure its accuracy. I don't believe that that was placed on the record.
Oh, no, and thank you very much. I appreciate that. I think it's always a good thing for counsel to comment upon. All right. While I've given a sentence that does involve a prison sentence, it is at the bottom end of toward the bottom half of the guidelines, which I think because of how she's handled this case, how she's dealt with the prosecutor's office, the police, how she's helped resolve the other cases, she has saved herself easily another 5 to 6 years. That may be something that's lost. I want to highlight that. The next thing is Ms. Jacobson, you may not feel it, but trust me, all right, maybe besides Ms. Castles, you're a lot younger than everybody else here involved in this case. So you got a lot of life from them. And that's what I'm trying to get to is the positive. You may not feel it now. That's the positive. You would have been sitting there until you were probably 42. But you'll be out well before that. You've got a lot of opportunity, maybe to come back here to the community, maybe and be a peer recovery coach, things like that. There's a lot of ways to look at this, and turning it into a positive as a learning lesson is what I really hope that you do. I really hope that we never see you here in a jumpsuit, but I do hope that you're always welcome to come by and chat. I have coffee with people on occasion, and I always like to hear about positivity. So that's why I want to turn this into positive. All right, thank you, folks. We are adjourned.
Thank you.